Welcome, everybody, to this symposium on public health, human rights principles in public health emergencies, which is really the culmination of a digital symposium that we have been holding, co-sponsored by the Petrie-Flom Center at Harvard Law School and the Global Health Law Consortium, as well as the International Commission of Jurists. I want to do a few things. I want to just set out some logistical issues for those who have joined us, and to first of all thank our co-sponsors. So this symposium is being sponsored by the Health Law Center at the University of Ottawa, the International Commission of Jurists, the Global Health Law Interest Group of the American Society of International Law, and the Global Health Law Consortium. And I'll say a little bit more about how many of those actors came together to create these principles over the last few years in a few minutes. For those who have just joined us, we have disabled the chat, so as the session goes forward, please enter your questions or comments in the Q&A. There will be time for the speakers to respond to those questions. We're first going to show a brief video that gives some background context on the development of the human rights principles in public health emergencies. And then I'm going to come and introduce our spectacular panel of speakers. And they will then go into different aspects of what these principles mean and how they might be applied in practice. So Giles, can we see the video now?
Sure, I'll just share my screen.
In 1984, when the ICJ was working for the first time on the Syracuse Principles, the challenge really to the human rights framework was states of emergencies that we'd seen in the 1970s and 1980s. These basic principles that government responses to any crisis have to be necessary, they have to be proportional, they have to be lawful, non-discriminatory, and restricted in time and space. These concepts have now been incorporated into customary international law. One area where state responses to crises has not been properly developed has been responses to public health emergencies. And the COVID-19 crisis put that front and center.
The fear and what it was like early on with hospitals overwhelmed, morgues, bodies being burned in different parts of the world.
States had immense power. Almost overnight, the states could arbitrarily decide that people stayed in, and they, as the executive part of governments, could make determinations which ordinarily they couldn't make.
The fallback for most governments, and for ours as well, was public order. The Public Order Act, the Public Order Regulations, which resulted in policing the pandemic.
But even within countries, what we saw is that it was the poor, the disadvantaged, the marginalized who suffered disproportionately. People whose rights were already not being respected were most at risk of suffering from COVID.
The world that COVID struck was one of profound socioeconomic inequality, where we had dramatically underfunded health systems, where we had capitulated greatly to private transnational interests, including pharmaceutical monopolies. And there was a gross imbalance in the global order between the North and the South.
I think human rights have been one of the victims. People lost jobs, children out of school. So that, I think, has been a collective failure, frankly, in protecting human rights at the times of crisis.
COVID-19 came to us in a way that we were never prepared in terms of human rights standards. We were not prepared to apply human rights in public health emergencies the way we've seen today, not in such a large scale. So in terms of precedents and legal reasoning. It's guidance for what to do. It caught many states off guard.
Very quickly, global health law was, the IHR of 2005 was somewhat marginalized. International human rights law was also marginalized, where states didn't notify derogations, where limitations were done without legal sanction, without the rule of law. And other actions were done that were wildly inconsistent with even kind of basic, well-enshrined principles in human rights.
International law failed us spectacularly during the COVID-19 pandemic. I'll take one example, being that of access to vaccines. You had a proposal by India and South Africa to allow for greater access to things like testing, to vaccines, to treatment. And instead of responding in sort of a timely fashion and a substantive fashion to address that demand, international institutions instead stalled in terms of making a decision. And then when they finally made a decision, that decision was wholly inadequate in terms of responding to the need.
Although governments had thought about how they might respond and how human rights might require them to respond in the context of other emergencies, very little thought had been put into thinking about them in the context of public health emergencies. And on the other side, public health experts and global health experts hadn't really thought about the practical day-to-day business of governing during a pandemic. And so we all really were having to work out how to deal with this and change the tire while the car was still moving.
What the ICJ and the Global Health Law Consortium are trying to do now is to address the gap that we've seen in terms of state responses by ensuring that responses to public health emergencies comply with human rights law. And in fact, to go a little bit further, to ensure that states understand that a human rights compliant response is the best type of response to public health and improves the response to the public health emergency.
The Global Health Law Consortium is honored to work with the International Commission of Jurists, bringing together experts throughout the world in global health law and human rights law to help to craft human rights principles and guidelines for public health emergencies.
The principles we're proposing are much more comprehensive than the Syracuse's because they provide a full range of human rights obligations that the Syracuse principles don't, especially in relation to economic and social rights. Yeah, they see human rights obligations involving positive measures, steps. Yeah, whereas the Syracuse principles are looking in preventing damage and containing rights or justifications for containing rights. We are giving justifications for rights realization in the worst scenario.
The justification of these principles already exists in human rights law. So these are obligations that states have already signed up to. In many cases, these are things that states are already doing. But what we are doing in terms of these principles is to get some of those obligations and really think about how they would apply in public health emergencies.
One of the most unique things with these principles is that we had a very interdisciplinary and we brought in approach to understanding what's a human rights-based policy or what is a human rights-based approach to public health.
It's just the simple brain power and passion in the room, which I really am loving to see. Everyone really cares about health. Everyone really cares about human rights.
So as Kellen, we work with communities, particularly communities that are vulnerable and marginalized. And this process has been useful for us in not just articulating the lived realities, but being able to appreciate that the normative framework can be moved and understood within their lens and their context.
I think the process that we're going through now is exciting in that people from a number of different perspectives are precisely doing that, are reflecting on the lessons that we've learned in COVID-19, but also previous work in Ebola, for example, and thinking through what are the gaps in international law, looking both at global health law, but primarily at international human rights law, and trying to thoughtfully fill those gaps in ways that would be useful to government policymakers.
The idea is that if governments do have some kind of document, some kind of good standards that briefly tell them, well, these are the things that you should think about from a human rights perspective, very practically, when the next health emergency hits, then they're more likely to actually consider those.
We're not only building on existing rights, but we are thinking about how rights might look like in the future. And I think that this is really super important because rights evolve. They don't remain the same.
The major achievement of the principles is that there's a broad enough consensus amongst a large range and variety of experts that there needs to be forward movement in the development of international law when it comes to human rights in public health emergencies.
This is our one shot. It'll never come again for us to really transform global health governance and human rights.
Human rights are almost always the first thing to go during a crisis. But actually what we see again and again is that they should be the thing that stays because they enable communities to have trust in governments. They enable communities to seek health services in ways that are not discriminatory. They enable a wide cross-section of people to think about the ways in which diseases spread. So if we put human rights at the center of our responses to health crises, we will be successful with the next crisis. And so these principles are really important for states as they think about the next crisis.
And if we can take that forward, and if we achieve pushing this discussion, and by the next global pandemic, which will occur, having a better place and states being in a better position to respond, then that will be a significant contribution.
So I want to start. My name is Alicia Yeaman, and I teach at Harvard Law School and Harvard Medical School, and I am a senior advisor with the Global Health Justice Organization Partners in Health, and I was privileged to participate in the process of developing these principles. I also want to acknowledge and thank Rujin Habibi, who wrote and directed that video, which really documents some of the process and the thinking that went into the principles, as well as my colleague Tim Fish Hodgson, who is the lead on economic, social, and cultural rights at the International Commission of Jurists. Before I introduce our four speakers, I just wanted to pick up on a couple of the points in the video and say a few things, possibly for those who are not immersed in international law, about the substance of the principles and the process we used. So in international law, when there are lacuna, gaps, it is possible to develop consensus principles based on the opinions of leading international jurists. And those have been used many times. In the video, they referred to the Syracuse principles on limitations and derogations under the International Covenant on Civil and Political Rights. But there have been many other efforts to expand on, or to, as Sharifa Sakala said in the video, to clarify the application of well-enshrined principles in international law to new populations, LGBTQ plus populations, for example, or to new issues, in this case, public health emergencies. And while Syracuse was referenced, and it certainly does build on human rights, my view is that the principles actually fill some gaps in international human rights law that were very clearly apparent during the pandemic, but also in global health law. So as was mentioned in the video, there was really the Syracuse principles were done 40 years ago. They were about civil and political rights, not economic and social rights. There was one mention of public health, but there was very little to provide guidance to governments and policymakers. And so this is quite a major compilation from other sources of international law that would feed into creating authoritative standards and principles. The other thing that has happened since Syracuse is that the world has changed. The challenges that are reflected in Syracuse were basically about curbing abuses of state power in states of emergency and in terms of terrorism, etc. But the world has evolved tremendously in the last 40 years, and we've seen neoliberal globalization and financialization really take off and affect the order in which human rights can be realized, the institutional architectures of our world. And that was very evident when the pandemic hit. So the principles talk quite a bit about regulation of private non-state actors, including corporate actors at the national level, but they also talk about quite a bit about the principle of international solidarity and extraterritorial obligations that, for example, wealthy states and multilateral institutions might have to react in ways that rein in obviously the efforts of pharmaceutical monopolies to extract profit, and the inequitable allocation of vaccines that stem from that. But you can imagine other extraterritorial obligations in terms of debt relief, special drawing rights, etc., that could be built into the principles, the justifications, and the logic that is enshrined in these principles. In terms of international health law, which has often been framed as a discipline of crisis, and the IHR in 2005, which expanded international sanitary regulation significantly, but these principles actually fill some important gaps, both in terms of what is covered, what is considered a public health emergency, and how it is responded to or prevented in a temporal fashion. So public health emergencies in these principles are not just diseases, not just a broader spectrum of diseases, but they can stem, for example, from conflict. And I think one of our speakers will talk about the situation in Gaza today. They can stem from climate catastrophe, and we may hear more about that. And in the temporal aspect, the principles, in my view, very importantly emphasize what needs to be in place before the disaster or crisis hits. We saw when the pandemic struck that health systems were dramatically underfunded. Governments in much of the global south were submerged in debt and austerity. And it's those structural things that I think we'll hear from a variety of speakers that allow or don't allow states to take measures that preserve and respect human rights during a crisis. Social protection measures, for example, flexibility in terms of labor rules and being able to take time off. And finally, another aspect I think that is important in terms of bridging and building out human rights law guidance, as well as international health regulations and global health law, is a real emphasis on meaningful participation. So this is not, we saw during the pandemic that global health experts often were frustrated because populations were mistrustful, and the principles talk about that trust and information, but also because they were issuing guidance that was kind of one size fits all. And often those prescriptions didn't take account of the many conditions of marginalized and vulnerable populations. And sometimes they didn't account for changing knowledge about the virus and just uncertainty about how it was affecting different groups. So the principles really strike a very important point on emphasizing that the decisions that governments need to take have to include meaningful participation by the people whose lives and well-being will be affected. And that, I think, builds out on the standards in human rights law, as well as the standards in global health law. And I'm eager to hear what the speakers have to say about these issues, as well as many others and their experience during the pandemic. The final comment I wanted to make in introducing this symposium is a little bit about the process we came to. So as I said, in international law, you can have these consensus statements from international experts, and that was a process that took about 3 years. We began this during 2020, and the final symposium at the Brochure Foundation was held a year ago, precisely. And then there was more work done post that workshop, and the principles were released at the World Health Assembly in May of this year. Now, we adopted a broader, the idea that there's a consensus statement of leading international jurists could be taken to be quite colonialist. Who are the leading international jurists? So we made a significant effort to include jurists from around the world, and also to kind of workshop or reach out to people who were not in the core group in French, in Spanish, to hold workshops in Africa, in Latin America, and to incorporate input based on regional and national experiences during the pandemic. And I think that has enriched the principles, and the plurality of perspectives has certainly tempered some of the narrowness that might happen by virtue of just including Western and Northern academics. And finally, I'll mention that the principles have already gotten quite a lot of traction since they were released at the World Health Assembly. In June, they were cited across multiple paragraphs of the Parliamentary Assembly of the Council of Europe's Resolution 2500 on public health emergency, the need for a holistic approach. They were presented to an OHCHR roundtable of UN agencies. A month ago, in commemoration of the 75th year of the Universal Declaration of Human Rights and the Constitution of the World Health Organization, the University of Ottawa held a symposium, an in-person conference and symposium that addressed the principles centrally. And there are already a number of recent publications. There was a submission to the Committee on the Elimination of All Forms of Racial Discrimination on their draft general comment on the right to health. Submission to the OHCHR study on access to medicines, vaccines, and health products. So we're delighted that the principles have been already taken up, and we view the digital symposium that we've held over the last few months, as well as this webinar, as an opportunity to really dig deeper into what they managed to do, where they fall short, how they might evolve and be applied in practice in different spaces. And with that, I want to introduce our panel of speakers and turn it over. We're first going to hear from Paul Hunt, who is a professor at the University of Essex in the United Kingdom. He is a national of New Zealand and the United Kingdom. He studied at Waikato University, New Zealand, and Cambridge University in England. And he's lived and undertaken human rights work in Europe, the Middle East, Africa, and New Zealand. He served on the UN Committee on Economic, Social, and Cultural Rights and was appointed as the first special rapporteur on the right to health. He also was an advisor to the WHO Assistant Director General, Flavia Bustreo, and for the last 5 years has been Chief Human Rights Commissioner of New Zealand. We will hear second from Luisa Cavalli, who is a very well-known lawyer specializing in HIV, sexual and reproductive rights, human rights, and gender equality. Luisa joined the UN AIDS in Geneva in 2015 as head of human rights and gender equality. And from 2019 to 2020, she was the acting director of the Department of Gender Equality, Human Rights, and Community Mobilization. She has led programs and the agenda for the promotion of human rights and equality in HIV, and she is currently the regional director for Latin America and the Caribbean, leading support to countries and communities to ensure the region meets commitments to end AIDS by 2030. Luisa also is very well known for her prolific advocacy and writing on sexual and reproductive rights, and her 16 years leading global programming and litigation at the Center for Reproductive Rights. Third, we will hear from Qayyum Ahmed, who is a South African human rights activist scholar who now serves as special advisor on the right to health at Human Rights Watch. And there he's leading the development of a global health strategy for Human Rights Watch and working on various global health projects, including the pandemic treaty that is currently under negotiation. Qayyum holds an assistant professor appointment at Columbia University's School of Public Health and is also now a fellow at the FXB Center for Health and Human Rights at Harvard University. He previously worked on ensuring equitable global access to COVID-19 vaccines as division director at the Open Society Foundations and Public Health Program. And prior to that, he served as chief executive officer of the South African Human Rights Commission from 2010 to 2015. And finally, we will hear from Justice Ayona Ntaba. Justice Ntaba is an extremely accomplished judge serving on the High Court, presiding over cases at the High Court Zamba Registry in the Eastern Judicial Region of Malawi. Her extensive legal career spans both criminal and civil cases, reflecting her versatile expertise in the judicial field. And beyond her role as a judge, she contributes significantly to legal policy making and legislative analysis at the national scale. Her interests are diverse but focus on energy law, international law, constitutional law, and human rights law. And she's passionate about gender, children's rights, and disability rights. And also about the intersections of urban law and development law. So with that, I will turn it over to our first speaker, Paul Hunt.
Very good to see some old friends again. Thank you, Ali. Thank you for your words, but also thank you for your remarkable work. I want to warmly congratulate everyone who's responsible for the principles. Special thanks to the Global Health Consortium and the International Commission of Jurists, but there are many, many others. Can I just personally acknowledge and thank Rujeen Habibi for organizing today and for getting me here today. The numerous institutions and individuals are acknowledged in the principles, the steering committee members, the key drafters, all the consultations, all the workshops, and the list of first endorsements as well. And clearly it's been a colossal, complex, challenging initiative. And in my view, the end result is terrific. And I also want to acknowledge the digital symposium last year, which is rich and instructive, and I commend it to you. I commend the inclusive process taken in the drafting of the principles as well. So very late in the initiative, I'm delighted to join you today, and thank you for inviting me. Clearly, the principles break new ground, and they break new ground in several ways. And I can imagine the difficult conversations that you must have had when preparing and writing and agreeing the principles. The early paragraphs in the principles are on international solidarity, and these are striking paragraphs. And I note that international solidarity attracts 2 posts in the 2023 symposium. And I sense these paragraphs on international solidarity reflect a new journey recently embarked upon and led by the UN independent expert on human rights and international solidarity. I've no doubt that international solidarity will be one of the several sites of struggle, if you will, embedded in the principles. I much appreciate too the attention in the guidelines, in the principles, the attention devoted to non-state actors, which Ali underscored. And this too is another site of struggle where we will have to work hard to advance the principles and guidelines. And I also welcome in the principles and guidelines the critically important attention to accountability, judicial accountability, but also non-judicial forms of accountability in paragraph 8. And I want to also welcome the careful attention to extraterritorial obligations set out in section 5, another site of struggle. There are many other important passages in the guidelines, and I want to mention one notable omission, which I imagine was much discussed. In very broad terms, there are 2 possible approaches to public health emergencies and human rights. One approach accepts that it's permissible to limit or restrict some civil and political rights because of emergencies, because of health and other emergencies. And this is, if you like, the sort of road to Syracuse. And that's one approach, and it's an approach that I'm very comfortable with. This approach tends to elevate civil and political rights, and it tends to relegate the right to health care and protection, and it tends to frame health as a human rights problem. But that's one approach, the sort of Syracuse approach, which the video talked to and Ali did as well. Another approach to public health emergencies and human rights requires fair and reasonable balances to be struck between competing human rights. For example, in the context of COVID, on the one hand, the rights to life, the right to health care and health protection, and on the other hand, the rights to assembly, movement, and work, and so forth. And the principles adopt the first approach. They adopt the road to Syracuse, and personally, I can accept that. However, because I favor a sort of holistic view of all human rights, I am interested in the second approach, and I would love to have been a fly on the wall when these 2 different approaches were discussed and agreed over the last 2-3 years. But nonetheless, I want to emphasize that I respect and affirm the position taken on this matter by the drafters of the guidelines and principles. Time is short. I'd like to make one positive, practical suggestion. And it's not original. I'm not claiming originality, not at all, but I just want to underscore it and to highlight it as a way of applying and progressing these excellent principles and guidelines. And my suggestion is a possible way, maybe when scrutinized, it doesn't proceed and it's not found acceptable, but the suggestion is a possible way to advance and action the principles and guidelines. And I'll try and set it out briefly. It seems to me that judges and lawyers will find the principles extremely useful. I suspect that health policy makers will find them more challenging. So it seems to me that we have to think about how to address the guidelines so that they are so they can be advanced by policymakers. But how to do that? And I suggest that literally it can be one or two health policymakers and one or two human rights workers can sit together and try to do the impossible. That is to strip back the principles to literally one side or two sides of bare policy essentials. Just one side or two sides that signal the key features of a human rights approach to public health emergencies. And the key features should be as practical as possible, building on the guidelines. In my experience, health policymakers want to do stuff. Frankly, they're not so much bothered about what the law says. They want to know what to do. So I suggest that we look at the principles and guidelines and identify 7 or 8, whatever it might be, key features, key practical features that policymakers must have in mind and must respect and must advance whenever they are wrestling with a public health emergency. The wonderful thinking and analyzing and polishing is completed, and it's superlative. But now I'm looking to what has to be done. So what might be these key features? Ali has referred to some of them already. One of the key features for policymakers to really grasp is the critical importance of authentic bottom-up participation. It's the critical importance of prioritizing the most vulnerable and disadvantaged, such as disabled people. And one lesson we learned actually from the New Zealand experience of COVID-19 was that if you listen to communities, if you give them resources, if you give them authority, then results improve. We know that from previous research, but it was confirmed in that New Zealand experience. Other key features, the collection of key data as disaggregated data, as much as disaggregated as possible. Another key feature, clear, transparent public communication in different languages. Another key feature, accountability, transparent, constructive, accessible, nimble accountability. Of course, judicial accountability has an important role, but judicial accountability is accountability of last resort. So we need imaginative forms of constructive accountability that mean we rarely have to rely on the judges. And if we want busy, stressed health policymakers to grasp and apply the principles, I suggest that when possible, we use their language and their concepts. For example, of course, human rights workers strongly favor the term equality, and for good reason, and I won't unpack those reasons for now. And the guidelines use the term equality, but in my experience, for some health professionals, the term equality has a negative connotation. That is, for some health professionals, equality means everyone has to be treated the same. Now, as human rights workers, we know that's not the meaning, but it's important, I think, that we recognize that health professionals wish to give distinctive, tailor-made, customized attention to especially disadvantaged populations, And many, not all, policymakers prefer the term equity, not equality. So in my view, we should be alert to these words and concepts if we want solid buy-in from health professionals. And as I begin to approach the end of my remarks, I want to make one related suggestion. The literature is voluminous, but the literature tends to set out 5 steps for good policy making. There is some debate about the steps, of course, inevitably, but broadly speaking, 5 steps to policy making, and it's a cyclical process, beginning with step 1, agreeing a particular agenda. Step 2, formulating different policies. Step 3, making decisions about which policies to go for. Step 4, implementation of those policies. Step 5, evaluation and monitoring. And then back to step 1 again. It's a cyclical process of agenda setting, formulating policies, making decisions, implementation, evaluation. So these 5 steps, of course, they're not set in stone. They can be revised, they can be improved. But in any event, policy making has various steps and stages. And I respectfully suggest, for consideration and possible rejection, that the policies and guidelines are integrated in different jurisdictions across the 5 policy steps. The principles can be unpacked, they can be folded into public health emergency policy making at the national level and at the subnational level. And this makes the principles more manageable, more practical. And this approach, critically, it requires interdisciplinarity. It requires people at the table who are medics, people who are epidemiologists, people who are health economists, pharmacists, human rights workers, people with lived experience. And together in that interdisciplinary way, we can fold the principles into policy, the relevant policy-making processes around public health and other emergencies. So to close, those are some short reflections. Firstly, my strong affirmation of the principles. I think they're a remarkable step forward, and I want to acknowledge all the work that has gone into them. Secondly, I am interested in views about striking balances between competing rights. Thirdly, for policymakers, I think we do need a pithy list of the key features of the principles when they're stripped down to application. And fourthly, how to consider the key features can be folded into the 5-step cyclical policy making process. Ali, thank you very much for giving me your time. Thank you, colleagues.
Thank you so much, Paul. That's it gives your endorsement is greatly appreciated, but also your questions and proposals. And for those who know Professor Hunt's work, you'll realize that much of the work he did as special rapporteur was really this kind of interdisciplinary translational work to try to get the right to health out of just legal domains into more programmatic and institutionalization. So I think you've really set up some great questions for the conversation later. Luisa, can I turn to you? Luisa Cabal from UNAIDS.
Thank you, Ali. And thank you, Rujin team and all the organizers for inviting me. It is a privilege to be connected again with old friends and newer friends. And maybe what I'll do is build from where Paul left us. I think that he drew upon 2 key issues that maybe I'll try to rejigger my remarks around. One is the nature of the importance of the interdisciplinary dialogue that needs to happen to realize the promise of the principles. And the other is, how do we translate the principles for policymakers? And why do I want to maybe reframe my remarks around these two important points? As a human rights lawyer who devoted almost 20 years to working around international human rights standards, with some dialogue to other disciplines, but not fully realizing the importance of translating those standards to policymakers, I have now been immersed for the past 2 years as a regional director of UNAIDS, actually trying to translate these dialogues to finance ministers, to health ministers, and to mostly a non-legal or non-human rights audience. And therefore, my comments draw upon this experience, and also from the importance of the principles, precisely because when I was back in Geneva, working to bring the lessons of HIV as we were facing the COVID-19 epidemic, we felt that we had the HIV experience and the human rights application of principles from the HIV experience. However, we were not being heard in the way we would have liked, drawing from those lessons. And I do think that having those principles will help us in making those points. And let me share some of those reflections. One, I really liked the framing a year ago, or almost a year ago, when the principles were being launched, and the framing around beyond panic and neglect. And this is how we felt when we were trying to draw from the lessons from the HIV epidemic in terms of how do we deal with this panic in a way that is framed in human rights principles. And unfortunately, we were not heard, and let me share some of the experiences that I do think that the principles will help with. One is around the principle of non-discrimination, and how do we make sure that any policymaker really is looking at the impacts and the discriminatory impacts of some of the measures. There are many of those measures that we know about in education, in lockdowns, violence against women, but also very saliently, right, the measures that around pregnant women, right, and the impacts it had. Or actually in the country where I'm located now, Panama, or in my own Colombia, where you designated days to go out for men and women, but then the harassment that trans people faced when going out in the lockdowns. So I do think that the principles will really push policymakers, ideally, to look at the disparate impacts of some of the policies. Unfortunately, also, we're dealing 4 decades into the AIDS epidemic with restrictions that were imposed decades ago. Let me share some of them. Travel restrictions that single out living with HIV for not being able to travel to certain countries. We're still dealing with the impacts of the criminalization of HIV exposure and transmission. So I do think that there's examples that we can draw upon to really push forward for the principles and the impacts they can have even across decades. The other issue of neglect, I won't discuss very much, because I know Ali mentioned it around the required measures on access to commodities and medicines, and how the principles are calling for the role, for the supervisory role of states on non-state actors, and Paul also mentioned this. I will just mention the role of the Global Council on Inequality, AIDS, and Pandemics, led by Widi Bianyima, and 2 co-chairs, including Sir Michael Marmot, around the importance of equity around access to life-saving treatments and vaccines. So I won't discuss that much, but I also would like to mention the importance of documenting some of what some would call the willful neglect of some communities, even when states were developing social protection schemes to deal with the most marginalized communities. To give you some examples, some states were actively excluding sex workers from cash transfer programs. So we need to look specifically at, even when designing programs such as social protection programs, who are we actively excluding, or who are we neglecting? And I think the principles help look carefully and call for looking at those most marginalized and the principles of non-discrimination. Paul also mentioned the issue around trust factors for policymakers. And I want to draw again on the principle of participation, but I think that UNAIDS is working to push that further with communities around community leadership. I think that I am very proud to say that I saw in action how one of our country directors in Peru, actually when facing the crisis of Mpox, worked actively to put what I would call the principles in action, meaning working hand in hand with the government to show the government why investing and working directly with the communities, with men who have sex with men, with the gay men, around translating the messages, how working on the fears of discrimination and stigmatization. This resulted in transparent information, in the active engagement of the gay community in bringing them for testing and for vaccination. So I do think, and I support Paul when we say we need to make sure that we roll out what this means for policymakers, and maybe drawing from positive experience of policymaking and governments working hand in hand to make this happen is a lesson to be learned. And finally, maybe I will also bring to bear something that the principles brings, which is the preventive measures and the importance of addressing systemic inequalities. A study actually released last year shows that countries with greater inequality have seen higher rates of AIDS deaths, new HIV infections, and COVID-19 mortality than similar countries of lower levels of inequality. And so the inequalities effort that Sir Michael Marmot, along with UNAIDS and others, are leading, are trying to draw upon this research that I do think working with all of you, Rujin, Ali, Paul, others, to show how we need not just to wait for the emergencies, but how are we working to unpack and work to disrupt this cycle of epidemics and inequalities that we and that the principles trying to address. One such example, I just want to give to finalize two such examples. One, when we faced the crisis of Zika, many of you remember that heavily hit Latin America and in particular Brazil. Well, many experts were calling on women to try to access more family planning, but as we know, the conditions were not there for gender equality, for women to decide when and how to get pregnant or to terminate a pregnancy in those contexts. So how are we continuing to unpack those underlying inequalities that exist and that then would not allow people to exercise those choices? But another area where we're working, and again, which are, like Paul and Ali mentioned, the most marginalized and the most vulnerable are usually the ones that will be left behind in the pandemics. And actually, overuse of criminal law has also shown us that it are leaving people behind, such as men who have sex with men, trans persons, sex workers, people who use drugs. So an important action actually in unpacking and working on those systemic inequalities will be to challenge those criminalization structures that continue to leave many of these populations behind. Thank you.
Thank you so much, Luisa. And I want to underscore the point that Luisa made about how we are still living with the impacts of restrictions put in place during HIV/AIDS. And there was a comment in the Q&A about why do we talk about the pandemic in the past tense? And that's really because of the decision by the World Health Organization to say that the pandemic was over. We fully appreciate that the effects, the sprawling effects of this pandemic on health, on economies, and on social relations are still ongoing. I would also use this opportunity to say, please add your questions to the Q&A and we'll get to them after all the speakers finish their presentations. Kayum, can I turn to you now?
Here we go. Thank you so much. Thanks, Sally, and thanks so much for inviting me to participate in this phenomenal conversation. I also want to add my congratulations to the authors of the principles and the organizers of this event for what I would argue is an incredibly helpful and elucidating set of principles, as well as the principles that have been further discussed in the blog posts and in the articles that have been written and the critiques that have been offered. They have all been really helpful in both my work at Human Rights Watch, as well as in my conceptualization of how the right to health has evolved through public health emergencies. And so I'd like to focus on two dimensions of the principles. First, what constitutes a public health emergency? And I'd like us to consider emergencies beyond pandemics and epidemics. And second, what does international solidarity look like? Paul and others have already made reference to this really critical component of the principles, and I want to perhaps expand on some of the thinking I've done around solidarity. And I'd like to think through these two questions by examining some of the work I've been supporting at Human Rights Watch on Palestine, and more specifically attacks on healthcare in Gaza. And so let me turn to the first question around what constitutes a public health emergency. I want to examine this question by referring to a poem by Dr. Sima Yasmin, who's a medical doctor and Emmy Award-winning journalist, and her poem is entitled "All the News That's Fit to Print," which is the tagline for the New York Times. The poem starts off with the following lines. She says, "Dark deaths matter more if they speak English. If our nurses are sent to help and return with trinkets, tans, and meningitis, editorial judgment dictates at least 16 Black people must die to equal one white man's death. 43, if the outbreak is old news, does not involve profuse hemorrhage, a former colony, or biblical references." And so this poem, I think, speaks to the question of who gets to decide what constitutes a public health emergency, but also when such an emergency is declared, what is the appropriate response? And I'm glad Ali mentioned the collection of experts that were pulled together to develop these principles, really embodied a wide range of folks from across the world. And I think it already speaks to the epistemic architecture of the principles. And so I argue that the principles really provide very helpful guidance on both these questions of what constitutes a pandemic and what the appropriate response, what constitutes a public health emergency and what the appropriate response should be. Because it takes a fairly broad view of a public health emergency, recognizing that while such crises may vary in scope and in nature, the safeguarding of human rights remains not only a legal obligation, but vital to an effective public health response. And I think this connection between public health emergencies and human rights is particularly important and has been incredibly helpful personally in an investigation that I supported at Human Rights Watch, centered on attacks on hospitals in Gaza between October 7th and November 7th, 2023. Human Rights Watch investigated attacks on or near several healthcare facilities, and we spoke with displaced people sheltering in hospitals. I spoke to several healthcare workers and hospital officials in Gaza. And then our digital investigations lab analyzed and verified open source data, including videos posted to social media, satellite imagery, and WHO databases. And of course, the investigation concluded that Israel's broad-based attack on Gaza's healthcare system is an attack on the sick and the injured, on marginalized folks, on babies in incubators, on pregnant people and cancer patients, and that these acts needed to be investigated as war crimes. I recall myself talking to a number of healthcare workers in Gaza, and as I was gathering evidence of potential war crimes, the principles offered a valuable framework for making sense of the violations I was documenting. And while I recognize these principles are certainly not perfect, and again, as Paul has mentioned, they really offered a sense of legal clarity that I particularly appreciated in the midst of an ongoing crisis and conflict in the Middle East. And then secondly, the component of the principles that I also want to focus on fairly quickly pertains to the second question, this one of international solidarity. And what I particularly appreciated about the principles is that it not only clarifies the human rights obligations in the context of public health emergencies, but simultaneously engages in what Tim referred to in that video as the forward movement of the law, what I perhaps would refer to as a form of epistemic innovation by advancing concepts such as international solidarity, which I think is really exciting and plants the seeds for a more dynamic and evolutionary understanding of health and human rights. The principles suggest, and I quote, that solidarity is an emerging principle of international law that refers to the shared responsibility of states and non-state actors to act together in support of others to address common challenges and to achieve shared goals, end quotes. And again, in the context of what's unfolding in Palestine, I would argue that South Africa's case before the International Court of Justice represents perhaps a form of international solidarity that I think and believe reflects the spirit of these principles. I think South Africa's case is essentially about Israel's obligations under the Genocide Convention, and I think puts its conduct in Gaza in sharp focus before the UN's highest judicial body. South Africa, of course, has asked the World Court to issue urgent measures to protect Palestinians in Gaza who face catastrophic living conditions, including an ongoing public health emergency, which is becoming increasingly unbearable and horrific, and as a result of the war crimes carried out by Israeli authorities. And South Africa further contends that the acts of genocide should be placed in the broader context of Israel's conduct toward Palestinians during its 75-year-long apartheid, its 56-year-long belligerent occupation of Palestinian territory, and its 16-year-long blockade of Gaza. And what was interesting to note around the commentary by political commentators and analysts, including by the very famous Jeremy Corbyn, is that they refer to this case brought by South Africa to the ICJ as an act of international solidarity, a term that Corbyn himself uses specifically. And so I would argue that this act of solidarity in some ways reflects paragraph 2.1 of the principles, in that it recognizes the duty of states to ensure that all individuals and peoples can contribute to and enjoy, as the principles set out, a social and international order in which their human rights can be fully realized. And so in conclusion, I am profoundly grateful for the work that you've all done in developing these principles. I recognize, as I've said before, that these principles have certain gaps, that they are not entirely comprehensive. There are things that could be improved upon, but I appreciate that these critiques that have been offered might particularly be relevant in policy spaces, but as someone who is attempting to apply legal principles in investigations, particularly investigations I'm supporting at Human Rights Watch, I find that these principles have been a source of important legal clarity and help me make sense of what's unfolding in a particularly difficult part of the world at this time. So again, my profound thanks and appreciation to you all, and look forward to the ongoing conversation and discussion. Thank you.
Wonderful, Kayum. Thanks so much for that. And your comments address at least partially one of the questions and comments in the Q&A about the application of the principles to humanitarian and conflict settings. And I hope we can come back to that further after Justice Nataba speaks. Justice Nataba, can I hand it over to you? Courts have played an important role during this pandemic. Sometimes, I would argue in the United States, not helpfully, but in other cases, very, very helpfully and crucially. So the floor is yours.
Thank you. It's always difficult to come after three amazing speakers and to speak, but I think let me speak from the practical point of view of the principles and how I as a person who's been a member of the judiciary, but also a person who was prosecuted and been a member who was in the Ministry of Justice as a legal state attorney. What I want to highlight with the principles is the fact that whether we are a dualistic country in terms of international law or monistic country in terms of international law, the fact that when it comes to the courts, the ability to have enough information or enough evidence that supports courts' positions, especially in the application and the promotion and the protection of human rights is fundamental. And especially when we talk about the concepts of access to justice. I say that because when you look at the principles, you do see that they are asking legal officers, they're asking judicial officers to actually take into account more diverse issues as they pertain to issues of health, and how those health concerns or parameters have an impact on human rights, especially during crises and emergencies. One of the fundamental things that we do note as we're going now, as the world is evolving, is the concept of scientific evidence being fundamentally crucial, especially even when you look at cases that came before the courts in terms of whether it was a COVID issue or an HIV-related matter, or TB, for instance. And those particular parameters of ensuring that the principles themselves highlight the importance of scientific evidence as part of the parameters of which courts or legal professions, especially those that are going to draft laws or they're going to draft policies, to actually take into account, becomes very critical. And for us as courts, it highlights the need for us to ensure that the evidence that comes before us has the ability to pass the scientific method issues, and they are internationally being recognized. And I think it is welcome that the principles do highlight that, look, if you're going to look about scientific evidence, there should be risk assessments and all those particular parameters that come into play. What I also loved about I was really like using the word love, but what I appreciate about the principles is the fact that it highlights into an area of law that a lot of judiciaries are not comfortable with, which is public health. Because most of the public health laws talk about quarantines, separation. They still do that because a lot of us still have a lot of laws that are public health laws that are very restrictive, have not yet moved with the human rights standards. And I say that because I know my public health law still has an issue with TB in terms of where a person is refusing TB treatment. And all those parameters are things that I think the principles are going to highlight, especially for us as judicial members, that, look, we need to start looking at the human rights implications of things that are dealing with the public health aspect. And for judicial officers, that becomes fundamental because we like to deal with evidence. We like to deal with things that have been put out and set out and argued out accordingly. And if you look at Principle 3, it actually calls upon the judiciary to actually ensure that they take all these into account. One of the things that are also fundamentally very significant about the principles is this ideology of ensuring that the rule of law is critical and central. And I think when we talk about the rule of law, a lot of us, during the crisis, one of the things that we fundamentally forgot is that the rule of law was already set and it has its parameters. in terms of how you can pass legislation, how you can pass measures. But somehow that particular parameter during the COVID crisis, you notice that a lot of countries suspended a lot of those particular principles, which go to the very essence of the rule of law. If you can just suspend them for willy-nilly like that, then there are problems, because it will culminate into people's rights being violated, rights not being promoted, and people being discriminated against, and people not actually accessing the necessary things. Because, for instance, it was easier for a person, for instance, if you look at a person who was poor, their ability to get masks at that particular time was very difficult, versus to a person who was able to afford it. And so if a person was caught without a mask, they could be arrested and fined, which is a double edge when you look at it. They already have problems with their poverty. Now you're adding on a fine. And if they cannot pay that fine, that meant incarceration, which also tripled the issue that they're not able to work, they're not able to do anything. So those particular parameters of ensuring that the judiciaries and the legal professions look at the retrogressive measures that came out of the crisis. And I think that's why Principle 12 is very important, that judiciaries and legal professions, especially, and I will go to policymakers and legislative draftspersons, because I think with public health crisis and with this particular COVID issue that we noted was a lot of laws did not go through the rigorous regulatory impact assessments that they need to go through. They also did not take into account what are the human rights implications, what are the financial implications on all sectors of society. And I think that is critical, that the legal side of things, the policy side of things, take into account. And they should do that before they come into the courts. Because what happened was the courts were now made to make those decisions, have to tell people that, look, you didn't take into account socioeconomic issues. You didn't take into account the societal needs for this grouping of people or that grouping of people. You didn't take into account, for instance, sex workers in Malawi were saying, look, we work at night. You can't tell us not to work. We can't be in the streets, we're on lockdown. All those particular parameters, I think it's very important that those are done before the rights violations happen. And these principles help us to get to that level, to avoid the rights violations, so that it lessens the need for people to actually sue, because by the time they're suing, a right violation has happened or is imminent. And it also takes its toll, because legal suits are not cheap. And those parameters are all things that I think when people look at the concept of access to justice, and especially in a part where there is a public health crisis, that cost element is not something that a lot of people consider. For a person who has had the rights violation, how then could they come before a court of law to actually want to get their cases heard, so that the rights violation that happened can be addressed, or that a right can be promoted? For instance, when we had the sex workers say, look, we have to be able to go to work. That takes a lot. So in terms of ensuring that the principles are practical, in terms of, for us, at least for the judiciary, for me, they offer me that practicality. They also offer me the ability that if I need to make a decision whereby I don't have the necessary law in my country, whether because we are a dualistic country and we haven't adopted certain international laws, but the principles help buttress certain positions of that international law. I could cite the international law, but the principles help to buttress the position that maybe I would take as a judicial officer, to say, look, this was particularly wrong in this particular parameters, because look, it didn't take into account the vulnerabilities of these people, the intersectionality of the laws, in terms of, you could decide that people could be under lockdown, but what about the right to education? What about the right to health? What about the right to work? And all those things. And I think the principles help expand those particular parameters for at least judicial officers to have some level of feedback that they can go back onto and say, look, this is expanded in this particular matter, that is expanded in this particular matter. I have reached my 10 minutes. interval. So I'll wait for the next level of questions from you, Ali. Thank you.
Thank you so much. And the endorsement from a judicial officer is so absolutely critical for these principles. In my view, the further clarification and translation is going to be critically important from judges. So we have very little time left, and we don't have a lot of questions in the Q&A. So I'm going to take the chair's prerogative and ask one general question for all of you, which is hard to come up with one general question after those presentations. But picking up on sort of threads from Paul's use of the term sites of struggle and Luisa's reference to beyond panic and neglect, Qayyum's focus on epistemic evolutions, and your focus, Justice Nataba, on how the courts are really at the end of a much broader funnel of policymaking and decision-making. The principles do a very good job at clarifying national level obligations and bridging out to international solidarity, as we've noted. But I want to focus now on questions about the obstacles to actually putting them into practice. Which in my mind are largely political and stem from the economic structure of our global order that makes it impossible, as Qayyum cited Article 28 of the Universal Declaration, for a social and order in which everyone can realize their human rights to prosper. So I guess my very broad question, which you can pick apart and answer in any way you want, is where you see those sites of struggle in a world ravaged by inequality within countries and between countries, and global governance for health that is also deeply, deeply colonialist, where you see the greatest obstacles to moving forward with these principles and any possible potential bright spots and pathways to move through those sites of struggle. And I guess we'll start in the same order with Paul.
Thanks, Ali. I think we, in order to deal with what I call the sites of struggle, and other panelists used other language for, I think, similar challenge. I think we need to build progressive coalitions. And I think we have to recognize that there will be some organizations, some institutions, some individuals that are going to be against us. But we have to hold firm to the basic values that are embodied in human rights and build progressive coalitions, and be prepared to peacefully and respectfully to challenge those in power. And it's not going to be easy, but we can't do it alone. So we need coalitions of progressives, if you will, to address those in power. And one of the difficulties is that those in power arguably have claimed human rights. So we have to, I think, go back to the values that are embodied in human rights and reclaim those. And human rights, I think, they need to be reclaimed, actually, for our time and place. So human rights, as we understand them, are incredibly important and valuable, but they do need refreshing for our time and place, so they can be useful tools for progressive change. Thank you, Ali.
That's such a great point. I mean, so often, you know, if we take, for example, access to medicines, in many ways, pharmaceutical companies have built and claimed that right? And without challenging the framework of intellectual property, it's a boon to those pharmaceutical monopolies. So I really appreciated your comments about people in power, actors in power have claimed human rights in many ways, and we do need a refresh. Sorry, Luisa?
Oh, thank you, Ali. Well, I will build on the coalition building, but I do think I'm not going to go to the macro sites of struggle but in terms of thinking positively and what could be done, I do think we need more interdisciplinary dialogue and action that can result in those coalitions. I do think that very often we're talking to ourselves, right? Lawyers to lawyers, human rights activists to human rights activists, public health, and not enough is happening around cross-fertilization. How do we sell these principles to other disciplines so that they join this struggle? And I think that, and in particular in the global South, right? I'm thinking in Latin America and the Caribbean, how do we bring it so that there's ownership and leadership in these interdisciplinary dialogues? And then empowering communities. I think that if you ask me for donors, what should they be doing is how do they, based on the learnings from HIV and that continued leadership for change, right? How are we going to empower the communities for them to be the ones carrying on this struggle and leading this struggle?
Thanks very much, Luisa. Kayum?
Similar to Luisa and Paul's points, I agree with your analysis, Ali, about the political impediments to realizing these principles. I also suggest that there are some epistemic barriers to giving effect to these and to realizing these principles and to ensure the evolution of the human rights space. And I think the examples you mentioned of pharma companies employing human rights language, which, as Paul has also mentioned, is a good case in point. I've seen, for instance, on Pfizer's website and Johnson & Johnson's website that they very publicly proclaim their support for human rights and the International Bill of Rights, of course, very much focusing on intellectual property rights as a component of the right to health, rather than on the full realization, progressive realization of the right to health. So I think what's going to be required to counter that appropriation of rights discourses is probably a form of epistemic disobedience, then, which is a term employed by decolonial scholars and thinkers. And I think this speaks to Paul and Luisa's points around building coalitions. And we could do so in many different ways. I also teach, as you mentioned, at Columbia. And so ensuring that these principles are incorporated into my health and human rights advocacy syllabus, writing about these principles, incorporating them into the strategy that I'm helping Human Rights Watch develop at the moment. These are all mechanisms and ways I think we can counter the unwillingness, the stubbornness to incorporate these ideas and these concepts into realizing the right to health. And so I think all of us on this panel, even though we might be, correctly talking to each other, as Luisa pointed out, I feel like we have some agency, some power and authority in the spaces we occupy, and we must use this effectively to advance the ideas that are captured in these principles.
I couldn't agree more with everything all of you said. I think we may have lost Justice Ntaba. Regine, can you just confirm that she hasn't been able to reconnect or by audio? Oh. That's too bad. There is a question in the Q&A about very interested in the issues of public trust in the face of future public health emergencies and how this was factored into the development of the principles. I'm happy to answer that, but also I'm eager to hear your views based on your different spheres of work during this pandemic and HIV/AIDS on public trust.
I think you should definitely answer this one, Nelly.
Well, I think that in the development of the principles, as I said at the beginning, it's impossible to develop public trust during a public health emergency. So by expanding the temporal range and focusing on what needs to be in place before a crisis happens, I think we try to get at public trust and elements of what would be necessary for that, including transparent and accessible information, and regulation of misinformation and disinformation. And there's been a lot of research during COVID-19 on the importance of participation, meaningful participation and voice by affected communities in building public trust. But again, those participatory mechanisms cannot just be stood up immediately in the middle of a pandemic or another public health emergency. Imagine Gaza, for example, So when there are communications available, when the government is functioning, that is when really the political institutions of government need to organize fora that enhance public trust. And that in turn has an implication for the health system itself, but it goes beyond the health system. How citizens reacted to government policies during COVID-19 went far beyond what specific public health officials were saying, and had to do in many ways with what Paul referred to as the trade-off between different rights, livelihoods and housing, and also public health. So now we have Justice Nataba back, and I'm wondering if you have any concluding comments about obstacles or ways in which we might advance the use of the principles. Justice Nataba? I think she may be frozen.
Sorry, is that me? Yeah, can you hear me now?
Not very well. Is it
Sorry.
possible to maybe turn off the video so that we can at least hear you?
Hello?
So you keep breaking up.
Ali, we have one question in the chat. Maybe we can turn to the question in the chat first.
Sure. Okay. So this is from Pedro Villarreal, who is now the chair of the Global Health Law Consortium and has been engaged with the principles for a long time. And it's really to Paul about the balancing that you mentioned, about balance individuals' rights to freedom of assembly and of movement on the one hand, and human rights obligations to protect those same individuals against the spread of disease on the other hand. And then it goes on about interdisciplinarity. and it's multiple comments, but he asks, what would be the main epistemic challenges for translating legal insights into practical policymaking considerations? And thanks you all for a wonderful discussion. So I think we'll probably end with that question and whatever remarks you have to share, Paul and others.
Thanks, Ali. I'll, the questions are extraordinarily good and profound, and of course, I can't possibly do justice to them. But I'll just make a couple of short remarks. And if I could revert to this idea of refreshing human rights for our time and place, I think it's going to be difficult and it's somewhat dangerous because authoritarian forces can use the opportunity to roll back the progress we have made with human rights. But so it's a dangerous process, but I think we do have to revisit human rights and refresh them for our time and place. And we do have to ensure that human rights have this holistic vision of human rights: civil rights, political rights, workers' rights, social rights, cultural rights, the rights of indigenous peoples, the right to a sustainable development, equality and non-discrimination. It's the whole package that has to be part of this refreshing of human rights for our time and place. It has to be other elements which, so interestingly, are in the principles and guidelines, issues around international solidarity. I think we have to find a place for them in a refreshed human rights framework. We have to think in terms of intergenerationality as well. We have to think in an imaginative way about constructive forms of accountability. And we have to think about, to come back to the question, the balancing of human rights. Finding ways of striking appropriate balances. And in order to strike those balances, we do need criteria, we do need guidance. And perhaps the criteria and guidance are not going to be hugely different from the Syracuse principles, but the starting point is different. The starting point is we have all these human rights, and then how do we strike appropriate, fair, reasonable balances? So I suppose my final point is that one of the reasons why I'm excited by the principles and guidelines on human rights and public health emergencies is because there are intimations in your guidelines. There are intimations of how we need to refresh human rights for our time and our place. So thank you all so much for allowing me to share the panel. Thank you.
I think that's a wonderful point on which to end. I also want to note to everybody that Justice Nataba her internet went out. There was a national blackout in Malawi, and that speaks to the background conditions that affect all kinds of abilities to communicate and enjoy rights as well. I want to thank each and every one of our speakers for their really great, profound and informative presentations and the conversation. I want to thank everybody who tuned in to the webinar today for taking the time. And I really want to thank my colleagues at the University of Ottawa, Giles and Regine Habibi, who has been an engine behind these principles from the very beginning. Tim Fish-Hodgson at the International Commission of Jurists, who has also shepherded this process through multiple ups and downs and issues. It's been an absolute delight to work with you both. And I also want to thank my colleagues at the Petrie-Flom Center, especially Chloe Reichel, who has edited the entire Petrie-Flom Center symposium. Thank you so much to everyone, and thanks for joining us, and have a good day or a good evening.
Thank you.